I would like to start our event today with a virtual trip in a grocery store. We, the consumers, we feel quite comfortable when we walk around the grocery store. We can find all kinds of brands we're used to. Well, let's go to the sweet drinks. Well, we can see Coca-Cola, Pepsi-Cola, Sprite, and because of those brands, we can differentiate. We can choose in the sea of similar goods, the goods that we need. And the brands, they convey the emotional images of the goods. This is the feeling of happiness with Coca-Cola, for example. This is the image they try to create. And because of the brand, we, the consumers, we can make our choice. And we are ready to pay for our favorite brand. We are ready to pay additional sums of money for choosing the brand we want. And also manufacturers, they feel good because they know who their consumers are, they know the preferences of the consumers, and they can suggest a type of product that the consumer needs. And the store is the place for the constant dialogue between the manufacturer and the consumer. This is the dialogue regarding the quality of the product, the main characteristics, the conditions of selling. And in this dialogue, the brands are going to play the leading role. Let's imagine the world without brands. The same store. Well, the same place where you buy soft drinks, but you don't see bright colors of Coca-Cola or Pepsi-Cola. Everything looks the same. And imagine that the same happens with other groups of products, with alcohol, with the foodstuffs that the government decided could be hazardous. Well, everything seems to be similar. No distinctive features. How real is this situation? Soft drinks, fast food, alcohol, and after tobacco, many countries are looking at those products as products that could affect the life of their citizens. In Australia, in Canada, in Great Britain, the tools are used to regulate those categories of goods, the tools that have been tested on tobacco products. And right here we have this saying, well, if you have a hammer in your hand, everything seems like a nail around. So after they provided uniform packaging for tobacco products in Australia, in Great Britain, when the government strategy was discussed regarding alcohol, they started talking about uniform packaging for alcohol. What is uniform packaging? We are talking here about packaging which is devoid of color and graphic elements of the brand. This is something empty. And what is the way you feel in the world without brands? You feel lost. You are deprived of the opportunity to make your own choice. But it's not just the consumer who is lost, but The producers also feel lost. They are deprived of their own brands. There is no connection. There is no feedback. The producer has no idea what the consumers want. So it's like a slapstick comedy when people bump into each other and just bypass each other without any recognition. And when we leave that place without bright information and we go around the corner, we get into the different world, the world of colors, the world of Coca-Cola, the world of Johnny Walker. This is the world where there is a dialogue with the consumer. The consumer is capable of making a choice. But this is the world where the consumer feels the dangers. And we are really aware of this world. We remember our old Soviet movies. You remember one of the protagonists who tried to find an electronic chip, and he goes around different stores and he couldn't find what he wanted to buy, so he has to approach a profiteer, and the profiteer has lots of bootleg products in his big coat. So this is the world of illegal trade. This is a real illegal world. This world doesn't pay taxes. This world doesn't play fair, and you cannot rely on good faith manufacturing and good faith consumption. Nobody's checking the quality. Nobody's providing reliable information to the consumer. The issues that we ask today is the limitation of individual property rights, and of course uniform packaging. It's just one of the ways of limiting the rights, intellectual property rights, and of course such limitations they are of real concern to us. And in the course of this hour, I would like to ask each of you to remember this image of a black and white store without any colors, the consumer who is lost and doesn't know what's going on, and also think about the producer deprived of colorful brands, and try to find the answer to the question, where is the borderline of government regulations? And where is the zone when it's not really acceptable that private liberties are violated? So now I would like to welcome our speakers, Professor Alexander Sergeyev, Professor Schroeder, head of the law firm Gorodidsky & Partners, Valery Medvedev, and director of State Intellectual Property Academy, Ivan Bliznets. Thank you so much. Thank you for this opportunity to listen to your expert opinions. And now I give the floor to my co-moderator, Constantine Kuzmian, a managing partner of DLA Piper in Russia and the CIS. Thank you. Thank you. I would like to introduce Olesya Trusova, senior advisor of senior legal advisor Philip Morris in Russia, and I would like to thank you for this very imaginative introduction. A couple of logistical issues. We wanted to give the opportunity to ask questions after the presentations of all the speakers. We're going to leave some time for Q&A, and also I was asked to remind you, to tell you that you can get simultaneous translation equipment. They are just behind you, channel 5 and channel 6.
The translation devices are in the back of your seats and running channels 5 and 6. Я думаю, это все.
I believe that this is all about logistics, and now I would like to introduce our first speaker, Alexander Sergeyev. He's a famous Russian civil law expert, one of the leading experts in intellectual property field. And one of the main contributions of Alexander Sergeyev for practicing lawyers was his work regarding editing of certain chapters of the Civil Code, and also he is not just an academic, he is not just a professor, but he is also a practicing lawyer, and he also helps us in DLA Piper. We're grateful to him. But now I would like to give him the floor. Good morning, dear friends. And in my presentation, I would like to talk a little bit about theory and the general approaches to the limitation of exclusive rights. And I would like to start with something which is the limitation of subjective civil law in general, and how is it applicable regarding a limitation of exclusive rights. And we're talking about limitation of rights quite often, but there is no legal definition, and that's why in doctrine of civil law this notion is presented differently, and limitation of rights quite often are considered equal with certain established limits or established bans regarding owners of rights, and sometimes the conditions are called limitations. And of course all those approaches can exist, but as it seems to me, every notion has the content of its own. I don't want to talk about the differences because additional time could be needed, and this issue is much broader than what we're going to discuss here. Now I would like to tell you right away what could be considered limitation of subjective limitation of civil rights. We must realize that there are certain limitations of general legal opportunities. So limitation of subjective right is narrowing the content of the right to use. This is not terminating the right, but it's somehow limiting the right, only that. And all the subjective civil rights, they are somewhat limited, and we cannot really doubt the fact that it's possible and necessary, because it's necessary to keep the balance between the interests of an individual and the interests of the society. And the humankind has been trying to strike this balance for hundreds of years, and now the goals and the limits of possible limitations of subjective rights are reflected in the International Legal Acts, Constitution of the Russian Federation, and the Civil Code of Russia. And the Declaration of Human Rights provides for the following, that when limitations are there, the limitations should be only lawful and established by the law, with establishing the recognition and respect of the rights of others and satisfying the requirements of ethics and general well-being of democratic society. And another international act on economic, social and cultural rights allows only such limitations that are determined by the law only when it's compatible with the nature of these rights in order to provide for general well-being of democratic society. And when we follow recognized principles and norms of international law, the Russian Federation established the following provision in the Constitution: the rights and liberties of human being and of the citizen can be limited by the federal law only to the extent when it's necessary to protect the foundations of the constitutional rule of law, life, health, defense of the country and security of the country. And this provision is also practically verbatim. It's quoted in the first article of the Civil Code of Russia. Limitation of civil rights could be done only for the purposes that are established in the above mentioned laws. And the European Commission on Human Rights established the rule of strict interpretation. No other criteria apart from those that are mentioned here couldn't be grounds for any limitations, and those criteria should be interpreted in such a way that the sense is not broadened. And a very important role in interpreting the goal and the limits is played by the Constitutional Court of the Russian Federation, which many times touched upon those issues. And the Constitutional Court of Russia outlined the legal positions regarding the principles, limitations, and acceptability of limitations of rights and liberties of citizens. And Chief Justice of Constitutional Court Valery Zorkin put it the following way: first, limitation of constitutional rights must be necessary, and they also should be reasonable regarding the goal of establishing these limitations. And when it's allowed to establish the limitations, the lawmaker cannot conduct the regulation that would infringe on the essence of a certain right, and it cannot lead towards losing this right altogether. Number 3, with acceptability of limitations of certain rights in accordance with the constitutionally accepted goals, the government, when it provides for the balance of protected values and interests, the government shouldn't use excessive measures, but the measures must be only necessary, and the limitations must correspond with the requirements of fairness and justice, be adequate, proportional, reasonable, and necessary to protect constitutional values. And finally, the limitations must be formally established, clear, without any broad interpretation, and without any possibility of discretionary use. But I would like to say that these limitations are not just limitations that are concerning constitutional issues, but also all the rights, including the intellectual property rights. And intellectual property is protected by the Constitution of Russia, by the way. And the establishing the approach towards limitations is somewhat special. When we look at the understanding of limitation of rights that was suggested in the beginning, so when we believe that limitations are only some limitations regarding the powers of rights holders, in this case the limitations could be connected with free use of intellectual property objects. So the lawmaker believes that it's not violation of exclusive right when the results of intellectual property sometimes are used by third parties without consent of the rights holder. A highly important role in establishing certain limitations is played by international conventions in the field of intellectual property, and now appropriate provisions regarding limitations of exclusive rights are reflected in various treaties on copyright, on tracks, and of course in TRIPS agreement. And there is a three-step test, and all the limitations must correspond with that test. And in accordance with this test, the limitation of exclusive rights could concern only separate cases specifically established by the law. Secondly, it shouldn't create unjustified damage to the use which is connected with exclusive rights. And number three, this limitation shouldn't violate the laws and the interests of the rights holders. And ideally, it should concern any violations regarding intellectual property rights. But we have to take into consideration two provisions. Well, first of all, those requirements are in separate agreements, separate documents, and in TRIPS those provisions are not general, but they concern the works of art, inventions, also prototypes, and trademarks. Regarding other objects of intellectual property, those limitations are not mandatory for the state. And secondly, regarding some of the possible limitations, some additional requirements have been established. In Article 31 of TRIPS agreement, we find 12 conditions regarding limitations introduced by the state. All that is regarding patents. Use of patents, apart from the cases when there is the will of the patent rights holder. And there are also several provisions regarding limitation of exclusive rights. And now these rules are in Clause 1, Article 1229 of the Civil Code of Russia. And in the beginning, this clause was quite short, and actually it just repeated three-step test which was mentioned before, and the conditions that could be used for possible limitations of exclusive rights, they were spread to all the objects of intellectual property, and from my point of view that was the right kind of a decision. And it's not just the TRIPS agreement, but actually it got further, because here we're talking about all the objects of intellectual property. But the federal law 10th of October 2010 regarding the changes to be introduced to Part 4 of the Civil Code, so there is a new wording, and the changes were such that a three-step test was excluded from the law, Instead, separate requirements were introduced regarding possible limitation of rights, regarding adjacent rights, and also prototypes, inventions, and copyright and trademark. And these changes they just copy certain provisions of the TRIPS agreement, and the only logical explanation of that approach is lack of desire of the Russian Federation to take more obligations regarding exclusive rights limitations than is required by TRIPS agreement. What do we have here? Paragraph 1 of the clause 5, old wording, has 4 important provisions. First of all, that's introduction of the limitation of exclusive rights. Secondly, the limitation of exclusive rights are going to be used with payment of the fees, without payment of the fees. And number 3, which is the most important, limitations of the exclusive rights could be established by the civil code and not by other laws, especially not by bylaws. And number 4, all those 3 provisions, they are dealing with all the results of intellectual activities. So regarding the criteria that limitations must correspond with, now they established by paragraphs 3 and paragraph 5 of Article 1229 regarding only 3 groups of objects. So we're talking about the works of art, then inventions and prototypes, and trademarks. And it looks like the limitations of exclusive rights regarding utility, model, typology of computer chips, also manufacturing secrets, place of origin, all that is not put into some kind of rigid limitations by the lawmaker. I believe that old wording was much better when 3-step tests could be applied to all the objects of intellectual property. And now, although replication of TRIPS provisions removes all the doubts regarding Russian legislation corresponding with the TRIPS requirements, but I don't think that this innovation is better for Russian legislation. In particular, if you don't know where those paragraphs come from, it's quite difficult to explain why they decided to provide different provisions for inventions and adjacent rights and prototypes on the other side, because the difference is only in the fact that in one it's about certain and special cases, and in another one it's just separate cases. And also they mention the lawful interests of the third parties, which actually is provided for in the provision dedicated to the works of arts and adjacent rights. And I don't believe that the wording, the final wording, is in good Russian. When they say that limitations shouldn't contradict just regular use. Maybe here we could talk about somewhat different wording in Russian, and or maybe we could use the old wording when the limitations shouldn't inflict unjustified damage. And finally, the rule established in paragraph 5, clause 5, article 2029 regarding limitation of rights trademarks. The limitations are established in separate cases, taking into consideration the interests of rights holders and third parties. Here we have some questions. Well, first of all, the Russian legislator here decided not to replicate Article 17 of the TRIPS agreement, which is mentioned the following way, that the members, well, they can take into consideration good faith use of descriptive wording, and if it takes into consideration the interests of the owners of trademark and the third parties. And I don't see any real difference between two types of wording if we make it equal for the terms separate cases, and also certain exceptions. And well, in Article 17 it's written that certain descriptive phrases could be used, but it's not necessary to mention it anyway. And the limitation regarding the exclusive rights of copyright of trademarks, well, they should correspond not with 3 but of 2 criteria regarding separate cases, and take into consideration lawful interests of rights holders and third parties. There is no requirement here regarding not creating obstacles for regular use of trademarks. And the absence of this criterion could be described by the differences existing in the limitations of exclusive rights regarding results of intellectual activity and the trademark limitations. And the limitations actually could be considered the limitations regarding of use of such objects. And we have to remember that when we're talking about the trademarks, well, that's also first paragraph of clause 5 of Article 1229, and those limitations could be established by the civil code only, not by other laws, and it should keep intact the content of the trademark right. Russian law provides for the opportunity of limitation of exclusive rights, but only in certain determined cases. Number 2, all those cases must be provided for by the civil code and not by some laws or bylaws. Those limitations must be determined by the goals they are introduced in order to reach. They have to take into consideration lawful interests of the rights holders, and those limitations shouldn't infringe the essence of exclusive right and shouldn't lead towards losing its real sense.
Unfortunately, these measures are not always implemented, as the other speakers will tell you about. Thank you. Thank you very much. I would like to present the next speaker. As our previous speaker said, the problems that we are discussing now, they are to a great extent related to the practice of the regulation of the same issues in the European Union regarding the obligations of the Russian Federation under many issues. And Philip Morris invited the professor of the Institute of the European Rights and International Public Law of Innsbruck University, Mr. Schroeder. He's an expert in the public law and commercial law, and he will speak about regulation of these issues in the European Union in a narrow manner with respect to the human rights and the consumer rights. Mr. Schroeder, you have the floor.
Well, good morning, ladies and gentlemen. Thank you very much for the invitation. First of all, I'd like to draw your attention to a handout that you will find on your table that contains a position paper which basically sums up my presentation so you can take something home from this breakfast. Well, I'll talk about the intellectual property as a human right from a European perspective. Human rights and intellectual property have numerous points of contact. And normally, rather the conflicts between those two areas are stressed. As most of you know, the legal protection of intellectual property may collide with individual rights of other persons, like, for instance, with the right to freedom of information or of data protection. And that has been extensively dealt with. But in an age of ever more intensive legal regulation by national and supranational legislators, which increasingly restrict the use of intellectual property, I think it's crucial to emphasize that human rights are the very foundations of intellectual property. And as far as I can see, this human rights aspect of IP law has been a little bit neglected so far. Why is that so? Well, in the arena of human rights, economic rights generally attract less attention than civil and political rights. And this is particularly true for intellectual property rights. Traditionally, they were not accounted among the indispensable liberties, but for a long time, intellectual property was rather deemed a privilege granted by princes or kings. And the human rights approach to intellectual property is a relatively new concept that goes back to the Enlightenment period. And probably all of you know that the concept behind the protection of intellectual property as a human right is that there is a public interest of states in promoting innovative activities and creative activities which contribute to the progress of society as a whole. From the legal point of view, that became manifest for the first time in 1787 in the US Constitution. But in many constitutions, for instance, like in the German or Austrian constitutions, or other constitutions, an express guarantee of intellectual property in the context of property protection is missing. And also in international treaties for the protection of human rights, intellectual property is often neglected. And as was already mentioned, the effective international protection of IP primarily takes place notably in sectoral treaties like the Paris Convention, the Berne Convention, or the TRIPS. So what is the situation concerning the human rights protection of intellectual property with us in Europe? And that's actually my topic, which I will deal with now. Well, neither in the text of the European Convention on Human Rights, nor in its first additional protocol, where the protection of property is guaranteed, IP is explicitly mentioned. Yet, since 2009, there is an additional human rights text which deserves to be mentioned in this context, and that is Article 17 of the Fundamental Rights Charter of the European Union. And that states, I quote, that intellectual property shall be protected. And thus, for the first time in Europe, intellectual property has become an explicit term within the human rights system, within the European human rights system, on the basis of which cases can be decided. And in my presentation, I shall address the question, what implications such normative strengthening has for the protection of intellectual property in Europe? And I shall deal with this protection from the perspective of the European human rights system as a whole. This system consists, on the one hand, of the European Convention on Human Rights, which is binding upon 47 members of the Council of Europe. And on the other hand, on the Charter of Fundamental Rights, which applies to the European Union and its 28 member states. Even though these two rights instruments have different addressees, they are closely interconnected as the fundamental rights with regards to fundamental rights protection. Because the European Union aligns itself, according to Article 52 of the Charter, explicitly with the human rights regime under the European Convention on Human Rights. The interesting question is, why was the protection of intellectual property expressly mentioned in Article 17 of the EU Charter? Well, by using the wording intellectual property shall be protected, the framers of the Charter draw attention to the fact that on the one hand, in the contemporary economic reality, copyrights, trademarks, patents often embody the essential value of a company, and thus they deserve specific protection. And on the other hand, they observed, what has been already mentioned by Ms. Trusova, that there is intensive regulatory activity in the EU. And that is becoming manifest in the area of product and consumer legislation, which constitutes a particular danger to the protection of such IP rights. And then the framers of the Charter decided that the express protection of IP rights in such fundamental rights charter is appropriate. And I would fully subscribe to that. The next question is, how has this development influenced the human rights protection of intellectual property in practice, notably in the jurisprudence of the European courts? Well, in general, case law of both of the European Court of Human Rights in Strasbourg and of the European Court of Justice in Luxembourg has until recently been rather cautious with regard to the protection of property rights in general, and this is also true for the protection of intellectual property. I'll start with the European Convention on Human Rights. In 2007, in the case Anheuser-Busch versus Portugal, the Strasbourg Court for the first time included trademark rights in the protection of property under the first additional protocol to the European Convention on Human Rights. Well, in my opinion, the recognition of exclusive rights as intellectual property is not the real problem. It is a question how effectively intellectual property is protected under the European Convention. That deserves, in my view, higher attention. Because just as other property rights, IP is submitted to the so-called social obligation regime laid down in the European Convention, and the Convention acknowledges the right of states to control what has already been mentioned with regard to the Russian Constitution, the use of property in accordance with the general interest. That is an explicit term used in the European Convention. And this is basically a justification clause that allows that the use of IP is in practice restricted through laws and regulations. The European Convention distinguishes different types of such interferences with property rights. A, expropriations of intellectual property, which can be of a formal or de facto character. And in the latter case, the question is whether, in the light of the legal interferences, a genuine use of the intellectual property is still possible, or B, mere restrictions of a specific use of intellectual property. In the end of the day, the question whether these interferences comply with the European Convention depend on their proportionality. And in that regard, the Strasbourg Court concedes to the member states a certain margin of appreciation, but the court has nevertheless made clear that any form of expropriation, formal or de facto, without compensation is incompatible with the convention. Yet as far I can see, this has only played a minor role with regard to IP rights in the case law so far. In practice, restrictions to intellectual property play a more important role in the law of the European Union, which I will address now. There have recently been a number of cases where the use of trademark rights in regard to foods, beverages, and, as has been mentioned by Ms. Trusova, tobacco products, was significantly limited due to the regulation of internal market law by the European Union. And this gives rise to the question whether such regulation is compatible with the Fundamental Rights Charter, and is particular with regard to Article 7 of the Charter, and regard to the property rights of the trademark owners. The European Court of Justice in Luxembourg has emphasized in the L'Oréal case, which is mentioned in my position paper you find in the handout, that the protected functions of a trademark under Article 17 of the Fundamental Rights Charter include above all, I quote, to guarantee to consumers the origin of the goods. But it shall also fulfill, I quote again, its other functions, in particular that of guaranteeing the quality of the goods in question and those of communication, investment, and advertising. So the protection of these trademark functions by the Fundamental Rights Charter and the European Union cover the presentation and design of the packaging of a product, since this is capable of either strengthening or harming the reputation of the trademark. Thus, danger for the fundamental rights in relation to the use of a trademark arise when the design or the presentation or the packaging of a product is regulated by law. And in the EU, this in particular concerns foods, for instance. Maybe some of you heard of the notorious health claim regulation, number 1924 from 2006, that requires manufacturers or prohibit manufacturers to use certain brand names for foods, inasmuch as these contain certain nutrition or health claims. For instance, the designation of foodstuffs as prebiotic or probiotic or something like that. Another example that has been mentioned concerns tobacco products, in this case by virtue of the Tobacco Product Directive from 2001, and this directive, as well as a successor directive from 2014, require manufacturers of tobacco products to print large warnings and shocking images on the packages of such products, and they also contain strict requirements for the packaging and presentation of such products. In such cases, the attractiveness of the product and the reputation of the trademark concerned obviously suffer from the regulatory requirements. And what is more important, that the trademarks can only be used by their owners to a limited extent in order to, I quote from the case law of the European Court of Justice, to acquire or preserve a reputation capable of attracting consumers and retaining their loyalty, as the ECJ put it in the Interflora case. In addition, the tendency of standardizing product labeling and packaging prescribed by EU legislation severely interfere with the essential function of the trademark as an indicator of origin. Trademarks cannot fulfill their communication function vis-à-vis the customer anymore. If the EU compels the manufacturers to use quasi-standardized product designations, packaging, and labeling, this creates the risks that consumers cannot distinguish anymore the products of one manufacturer from the other. And this problem would even exacerbate if the EU or single member states introduced an outright plain or generic packaging for specific products, as has already been mentioned by Ms. Trusova. That means a complete standardization of product packaging in regard to form, color, imprints, which, in order to make those products as little attractive to the consumers as possible, which is exactly what's happening in countries like the UK or Ireland. And this kind of packaging requires the complete removal of all branding through colors, logos, or trademarks. What is the position of the European Court of Justice with regard to those restrictions? The ECJ has hitherto accepted certain restrictions to the use of trademarks, for reasons of public policy, namely in regard to health, consumer protection. It deemed such restrictions to trademark property, for instance by requiring to print warning notices on packages, as proportionate. The court has stated that manufacturers, in spite of such strong restrictions, may still, I quote, continue to distinguish their products. And this possibility would arguably cease to exist in the case of a mandatory plain packaging of tobacco products or foods or beverages, where the appearance of products is completely standardized. I think this development will probably prompt the European Court of Justice to scrutinize the proportionality of such further-reaching interferences with trademark rights more strictly in the future. And I guess I dare to say that this prediction is justified, as the European Court of Justice has, since the entry into force of the Fundamental Rights Charter in the EU in 2009, generally devoted closer attention to fundamental rights interferences on the part of the Union, but as well as on the part of the Member States. Several spectacular judgments testified to this development. Legislators must strive, in the light of the new jurisprudence, for an adequate balancing, as the Court of Justice has called it, a balancing of the public interests on the one hand and the interests of the property owners on the other side. Thus, in my view, the European Court of Justice could qualify substantial interferences with international property, such as the introduction of plain packaging, as disproportionate, since it would amount to a de facto expropriation of the trademark owners. In my view, it violates the very essence of a trademark, because the normal usage of trademarks is no longer possible. And this development, which is my resume, will not leave the Court of Human Rights in Strasbourg unimpressed, because the European Convention on Human Rights and the Charter of Fundamental Rights of the EU have jointly created a European human rights system which has its impacts throughout the entire legal cosmos in Europe. And the European Court of Human Rights will arguably take into account this recent jurisprudence of the European Court of Justice in regard to intellectual property protection or property protection as a whole. Thank you for your attention.
Professor Schroeder, огромное спасибо за ваш...
Professor Schroeder, thank you very much for your intervention and for the European vision on the human rights and intellectual property rights. Packaging is a complex result of the intellectual property rights. Packaging provides for the property for the intellectual rights and other rights. I would like to ask Mr. Bliznets, the chairman on intellectual rights of the Chamber of Commerce. Nalia Anatolyevich, looking at the intellectual right, do we have some provisions in the Russian legislation to limit the intellectual rights application? Good morning, dear ladies and gentlemen. It's always pleasant to work in the business life community. I would like to say the following, that today and in the near future we are discussing the future of intellectual property rights, and it reflects the position of the legal experts which will influence the future. Now, I just have been thinking while listening my friend, professor, we've known each other for many years, Mr. Centrovin, the author of our first manuals on intellectual rights, and our European professor. And we see that there is a trend in this society to review the main prerequisites of intellectual rights, which is exclusive rights or titles, which is quite dangerous or perilous. The ownership as the permanent right is coming from the Roman law, and no one has ever thought about this. Let's just start reviewing the principles of Roman law and do what we want with that. It's quite dangerous if we go along this way, if we start reviewing cardinally the principles of the intellectual law. This is a basic groundwork where, on the basis of which we try to build all our relations, legal relations. And all exclusions are not inevitable, and we need to understand it very well, especially in the situation when we have such an extensive access to the information and so on. But I would like to stress that now we should be very careful in order to preserve the main fundamentals in the area of the intellectual property. And we need to ensure the balance to preserve the system of intellectual property in the world at large. And it's not by chance, and experts know very well that the basis of this system is founded on the international legislation and agreements. It is very important in Russia that this principle, to maintain these principles, which are kept in the constitution and in our civil code, which is the economic constitution. And the review of these fundamental principles should not give some prevalence to either side. Moderator said that the issues related to the trademarks and ownership are protected by the economical laws and respective legislation, and by the ownership legislation like packaging and design, which is distinguished features for the consumers. When you go to shopping, and my colleagues have said about this, each trademarks have their specifics, which are distinguished by the trademarks or ownership. And it is very important that many trademarks are sometimes the pieces of art, because this is the result of creativity work, especially when we talk about the packaging. This is the work of designers and artists, and these rights are protected by the ownership rights. And we see today that limitations or exclusions sometimes cover both fields of this legislation. Another important thesis: these limitations or restrictions should be quite cautious. They should be based on the interest of society and human being. Currently, in the field of the ownership of the trademarks, these restrictions are quite clear. They focus on specific groups of our society or citizens. And just recently, you might know, in 2013 we adopted the Marrakesh agreements on the ownership's rights, which distinguished these limitations and relates to the pieces of arts of blinded persons, with challenged persons, and with some hearing problems. And today, in the Committee on Ownership and Patent on Intellectual Rights organization, we are developing another protocol to the libraries or archives, which in future would be related to the science communities and other communities. And we see that international law is going by the way to distinguish the rights of various groups of society. When we start discussing this kind of limitations to be introduced, and I'm sure that we shouldn't discuss it at the level of the government. These limitations or restrictions should be, in the first place, should be provided by the international law and should be provided by the main document, civil code. That would mean that they would prevalent force and would maintain the main principle which is contained in main international organizations. And I would like to draw your attention to another topic which we discuss when we talk about restrictions or limitations. There are some approaches of the experts to these restrictions.
Those limitations should in no way revise the main convention, Berne Convention, Paris Convention regarding protection of industrial property, Rome Convention. And this is highly, highly important, because sometimes some hotheads are ready to revolutionize everything, revise it all, change it all, and they say, oh, Berne Convention, it's so obsolete, let's revise it. This is one of the cornerstones. As one of my postgraduate students said, that Berne Convention is like American Constitution. It's a pillar. It's a foundation. And this is the foundation for intellectual property. In the future, when we deal with these issues, we must get through this system of limitations and exclusions. We must introduce new international acts and introduce changes into our civil code. I'm going to give you maybe the last example, the newest example. Maybe you heard on the 22nd of May, we had the meeting of the Intellectual Property Council, which is headed by Valentina Matvienko in the Federation Council, and they discussed the concept of this government strategy of intellectual property in our country. And they discussed general approaches, slogans, and suddenly, they provided an example regarding prototypes. That the prototype is a special type of a protected object, and the principle must be introduced when the manufacturer started the production. And the government must provide the protection. Wait a second, where is it going to lead us to? It's going to lead us towards a revision of the whole system of intellectual property protection. Why, in this case, we are using Paris Convention and the Civil Code, which establishes the main principles of protection of such objects only by way of registration. registration only. You remember in the Federation Council we discussed one issue which our colleagues tried to raise regarding the protection of confectionery. People spend some money on advertising, on promotion of well-known trademarks. Those trademarks are protected, and it's suggested that okay, let's nationalize it, let's divide it among everybody and let the manufacturers do whatever they want to do. Such revolutionizing steps are not needed, and I urge you all, don't create revolutionary measures. When we're talking about packaging, when we're talking about prototypes, when we're talking about trademark, we, the consumers, we distinguish every type of goods. We know what we're buying. If we violate the principles all over the world, and as I understand our colleague from Europe also expressed similar concern, it's going to lead towards certain concerns. We are going to flood our countries with pirated goods. This way we are going to open the gates to low quality and hazardous products. The consumer is not going to distinguish good from bad. Yes, this gray zone store. Let us be careful and let us think together. How could we not violate the balance? Thank you for your attention. Thank you so much for your presentation. Valery Nikolaevich, Mr. Bliznyets looked at design packaging from the point of view of copyright. What's your opinion from the point of view of a patent attorney? Valery Nikolaevich, he's a managing partner of Gorodisky and Partners. He's a practicing lawyer, and Valery is one of the best experts in intellectual property field, and American publication Best Lawyers noted his achievements. Also, English edition Who is Who also mentioned him. So, Valery, you have the floor. Good morning, distinguished colleagues. Thank you so much, Olesya, for this wonderful introduction. I would like to continue our discussion today, and I would like to touch upon the limitation of the right to use a trademark. And before I start discussion of this issue, I would like to introduce the notion of intellectual property as a legal mechanism which was established together by the society and the state in order to help technical progress, protection of investments, and also creating good faith competition in the market. And because trademarks are objects of intellectual property, they become highly important elements of this mechanism. Legal protection of the trademark is provided when the trademark is officially registered, and the government established the conditions, what are the grounds to provide such protection and deny such protection. And here we can see some contradictions to the interests of the society and ethical and humanitarian principles. That's why it's quite clear that if the trademark is protected, so introduction of any changes by the government regarding the use of a registered trademark by the way of allowed by the government, well, no limitation should be allowed And also it's quite necessary to say that when the government assessment is conducted, when there is an application to register the trademark, the experts are looking at the grounds, and if the reasons were not established, that means that no further limitations are possible on these grounds. And in principle, it's quite evident, and it was clear till a certain moment of time. When in Australia in 2011, they passed the law on so-called uniform packaging of tobacco products. That law was introduced on the 1st of December 2012, and then some other countries are using Australia as an example. They started looking at similar draft laws. In some countries those laws were passed, in some countries they're quite close to be passed. And I would like to establish some of those countries, for example, New Zealand, South Africa, France, Ireland, Great Britain. And the discussions, well, in Australia, tobacco products were considered hazardous, but in other countries, those goods, those goods make a much longer list, and I would like to introduce some of the measures that were introduced by those laws that are supposed to limit the use of trademark on packages and goods. Well, first of all, strictly uniform packaging is being introduced that should contain the warning about health hazards. The text and the picture must be there, and that warning should take most of the packaging. Instead of the original trademark, it's suggested to write down the name of this trademark using one uniform font in one of the parts of the face of the packaging. And I would like to show you some of the examples connected with these measures regarding tobacco products. How is it supposed to look like? And you can see that original packaging doesn't really urge people to smoke. And purchase this very product, and it's only connected with the fact that a number of certain group of consumers could feel connected to that product in the store and could be looking for such product, Lucky Strike product. Regarding the new packaging, you can see that the situation is quite different, and we don't see our trademark and legitimate trademark. And the next type of goods, well, those are alcohol drinks and soft drinks. Coca-Cola example is given, and you can see that you can see how a can of Coca-Cola or Pepsi could look like. It's a soft drink, it's not alcohol. Next type of goods, some groceries. So we're talking about snacks, some sweets, and also fast cooking products, and the original packaging and how this original packaging could be transformed, and how the new packaging could be created. Regarding the next group of goods, well, these are pharmaceuticals, and Some people wanted to make it even worse. They're not just removing the original trademark, but they want just to have the description and just write down the name of the chemical substance which makes this medicine. Here, the example, well, we have this simple ointment in Russia called oxalin, but you can see what is there. 37 letters in this word regarding the chemical formula. A normal, regular person wouldn't be able to pronounce this word because you need a professional chemist to pronounce it. But we can see that the hotheads can get further. And here's one of the slides I encountered when I prepared this presentation. And people discussed the limitations of the copyright, of the trademark use, and finally we could consider cars hazardous goods using this logic. What happens in our country? Once again, I wanted to mention to you that intellectual property, so this one of the rights which is guaranteed by the Constitution of Russia, Article 44 of the Constitution. Also, Russian legislation in intellectual property has certain special feature. It establishes a positive part of exclusive rights in Article 1229 of the Civil Code of the Russian Federation. The rights holder has the right to use object of intellectual property, trademark, at his discretion in any lawful way, not contradicting the law. And those ways are mentioned in the open list. And it's provided by Article 1484, and one of the rights is the right of the trademark owner to put the registered trademark on the goods and packages. And getting back to Article 1229, we can see that the limitation of exclusive rights is established in separate cases, taking into consideration the interests of rights holders, third persons, and consumers, not just rights holders. And Russia has certain international obligations that were established in international treaties. I would like to mention three of them. Paris Convention, the Agreement on Technical Barriers in Trade, Article 2.2, and Article 20 of the TRIPS Agreement, where it's written that use of trademark should not shouldn't be unjustifiably limited by special requirements. One of the main functions of the copyright of the trademark is to be able to distinguish the product of one producer from the product of another producer. And if we discuss this issue seriously at the level of the cabinet of the Russian Federation, and if they prepare certain draft laws, everything should be done in the framework of the Civil Code of the Russian Federation. In this case, we must view the following of the interests of the owners of trademark, and what could happen if we have uniform and no name packaging. Well, first of all, in this case, your right of property is taken from you. Number two, your investment is wasted. Goodwill is lost. Goodwill could be created in years. Even Coca-Cola, which was mentioned here many times, it has 150-year history in the international market. And of course, no trademarks, no competition. That's pure death for the economy. And regarding third persons, including consumers, this is when the damages could be inflicted. And I'm going to mention three types of damages for consumers. So we'll have more pirated goods that are going to flood the market. If you get back to one of the slides, those simple packages, you can imagine that it's going to be easy to use such simple packages and get lots of pirated goods into the market, because designer packaging is more difficult to fake, and there is no real choice. We are looking for brands when we go to the stores, and of course we're going to have lower quality. In such packages we're going to find low quality products, because that's going to be a lot of fake goods, and again you don't follow the interests of the third persons. And the last thing in this system is the government. In principle, it's not good for the state, it's not profitable for the state. You have to think about huge compensations that you have to pay to the rights holders, because you cannot deprive them of their right which was provided by the owner of the trademark. When we're talking about the groups of goods that we're discussing today, Coca-Cola, specialized agency in the brand, creates annual assessment, and umbrella brand costs about $60 billion for Coca-Cola, McDonald's $41 billion. It's not a big joke, because a lot of money is involved. Of course there will be less taxes, there will be more money to be used for law enforcement, because more and more fake goods will be found in the market, and increasing the number of consumers of hazardous goods. Why? Very simple package will lead towards lower prices. If in general price a large part for original packages is necessary, but in general we get better value and the price is getting lower, and people won't be ready to pay more. And in conclusion, we have the situation when we must take care of our health, of healthy diets, but we have to take care of intellectual property, which is protected at least by the Constitution. That's why when we introduce those limitations, naturally we must take into consideration the issues of following national legislation. and we have to take into consideration the lawful interests of trademark owners, third parties, and also we must wait for the WTO decision regarding legality of those changes introduced by the government of Australia. And in principle, experts expect that decision next year. Let's wait and see. And highly important, I already paid attention to it when I quoted Article 20. So the measures should be upgrounded. You cannot just introduce the measures without proving the significance of those measures. How could those measures lead towards lowering the consumption of tobacco? In Russia we have several types of troubles, but we try to get rid of alcohol abuse, and I don't think that trademarks create the main motive for people to consume alcohol. Well, there are different grounds, and I believe that accessibility, price, and some other issues are involved, and also we're dealing with the social and economic conditions regarding alcohol consumption in our country. And we must be very cautious about the measures. When we're discussing limitations or the bans. Thank you so much. I would like to thank all our speakers for this morning session. I'm not going to sum it up for a long time, but it's difficult for me not to share my impressions. I don't know about distinguished audience, but I feel very anxious because of our future. And Ivan was talking about the issues that we discussed today. It was something existential for the future of intellectual property, and Olesya created those terrible images for us at 8:30 in the morning of our future life, which is so colorless, so sad, so deprived of colors and gender, and it reminded me of anti-utopia created by Orwell, and I remembered maybe the best anti-utopia in Russia these days, created by Vladimir Sorokin. The Day of the Oprichnik. I'm sure that a lot of you read it, and I recalled that Sorokin took a very tough approach, and there was total monopoly there, no competition, and from the point of view of those scarce brands and some bright colors that were present, that there are not too many, and there could be only two of them, and they had their own brand identification, and even in that terrible utopian world which was depicted by Sorokin, and the novel is becoming more and more prophetic, and now we are looking at it as the intrinsic part of that bad scenario of the development.
So using the efforts of the legal community, consumer, producers, so I hope we avoid this future. We have just some minutes for Q&As, and the topic that we should discuss is the approaches to these problems in the context of Eurasian Economic Union, technical regulations. I know it's quite hot topic of today. If you have any questions, it would be very interesting to listen to your intervention related to this. Thank you very much. Good morning, BMF Group, Kazakhstan. This is the view from Kazakhstan. In addition to what the previous speakers have said, I just would like to add that, like Valery Nikolaevich, I would like to dwell on trademarks, because this is a huge topic, and I would like to summing up that restrictions are applied to the use of trademarks, location of trademarks, time of the day of the use. Limitations are also applied to the age of consumers, and this relates to the protection of health or protection of trademarks or significance. And in Kazakhstan they are discussing the introduction of limitations on the basis of academic sensibility. This is the exhaustion of ownership rights, and the possibility to use these rights with respect to the specific category of goods. This relates to the spare parts of the cars. In Kazakhstan, we don't have a definition at what level these restrictions should apply. In Russia we have civil code, but in Kazakhstan we don't have such prescription. And these limitations are imposed on the basis of various decrees, be it governmental decrees or other decrees. And we believe that these limitations could be imposed by the Eurasian Economic Union decisions. And we see that these limitations are applied to the principle of exhaustion of law or ownership rights. We believe that the Eurasian Economic Union is growing, and we see other members are joining this union, like Armenia, with the temporary request to limit some rights during the first years of membership. So we believe that these decisions regarding the limitations of rights, be it the use of trademarks or the time of use of trademarks, should be based on joint or mutual decisions, based on intergovernmental decisions. And we need to ensure the systematic approach to what we need to restrict and to limit, not only trademarks. Just several slides. Can you go back? Over last 20 years, this package has changed in Kazakhstan. for several times. This is how it is registered, and now this is how it looks like. You see another limitation on the use of ownership rights. In contrast to the Paris Convention, which says that the trademark should be used as it is registered, the manufacturers are limited in this right, and this trademark is used with another object of ownership, which is the picture, and you see this picture belongs to other people, companies, and this is transferred to Kazakhstan to use as the preventive measure. In Kazakhstan we don't have any specifications or explanations. Should we consider this limited use of ownership as restricted? And that is why it's not clear. Can we use this trademark because, or can we revoke this ownership because we have a limited use of this ownership, and the owners of these rights should apply for several times to register this trademark, which is the burden for the trademark ownership to protect their rights. Next slide. Not this, another one. Here we see what using different colors. Psychologists have been working very hard to identify what is the best color for what is the less pleasant color for a human being. This is the color which is not pleasant for a human being. This what is spelled in different manner, and you see the most unpleasant mode of spelling this word. Go back, please. Here you see the packaging which are mainly used. The trademark is present not in the best colors, not in the best amount, and you see that it's not appealing manner to describe the name of the trademark, and this is obligation for the manufacturer to identify its trademark. Valery Nikolaevich in his presentation said the future of trademarks if we use the unified packaging. Can you go back in terms of presentation? So this, you've seen this package for the fast food products, wine. I wouldn't like to use this wine to be during my festivities and to see it on my table. And in Australia they are discussing these legal aspects to prevent the appearance or the introduction of the use of these labels in Australia. And I believe Australia is not the first country where this obligation would apply. This is the mandatory labeling for the alcoholic products in the Great Britain. I would like to have these bottles on my table as well. Alcohol is not always harmful, because if you drink moderate, then it is considered as a good thing for your health, and I prefer to drink good wines. Geographic denomination or geographic indications on the food product, using the pictures of the parts of the human body, like in the tobacco products and other products. Let's skip it. It's not pleasant for the breakfast, I think. The gambling machines, another category which is not related to the food products but also related to some kind of the same things, and other types of indications in the dairy products or milk products for kids. And South African government is using these indications. We understand the processes, but the processes should be well thought, and once we are forming a common space, they should be discussed by the governments. We shouldn't make hasty decisions, and we should identify the efficiency of the measures we are using, and after a well-thought deliberation or discussions of these measures and agreements by all members of the Eurasian Economic Union, we should apply any limitations for the use of the trademarks. Thank you very much. We don't have any time left. The topic is quite relevant. It's pity that we don't have enough time to discuss other issues, but I'm pretty much sure that we will continue this discussion in the future.